Welcome everyone to the On the Docket podcast. This is the second episode, and for this one we're going to be straying away from the rights of the accused, which we explored last episode, and dip our toes in a nice little First Amendment free speech case. And this isn't just any free speech case. Oh no. This is a student speech case. How much can a school suppress their students? Well, we're about to find out. I think this case will be especially interesting to those students with astronomical IQs who, whenever they get in trouble for saying something inappropriate during class, they always reply with some snarky comment about how they have the freedom of speech. With this case, we're going to see if those students actually are protected by the First Amendment. Today, we're going to be talking about Morse v. Frederick. First though, let's add a heaping helping of context. The year is 2002. The Winter Olympics are being held in Salt Lake City, Utah, the coldest place on Earth and probably the best choice for the Winter Olympics. Up north, in the much warmer city of Juneau, in the desert state of Alaska, they're having an event to celebrate the upcoming Olympics. This event is an Olympic torch relay. Think of it as kind of like a parade. It's a televised event where people carrying the Olympic torch run through the streets and people standing on the sidewalks clap and cheer for them. Near the path of the Olympic torch relay sits the Juneau Douglas High School. The principal, Deborah Morse, decided that it would probably be fun and interesting if she lets her students stand and watch the relay. It is just across the street after all. So these high schoolers are standing on the sidewalk across the street from the school, but technically not on school property, watching this relay happen. That is when Joseph Frederick, a student of Juneau Douglas High School, shows up late to the event. Presumably he had not attended any of his classes that day. As the cameras pan over to the position where he is standing, he and his friends unfurl a 14-foot-long banner that reads, "Bong Hits for Jesus." Deborah Morse rushes over to the students and demands that they take down the banner immediately. Frederick refuses, citing his First Amendment freedom of speech. Morse takes matters into her own hands, confiscating the banner and suspending Frederick. Her concern was that the students were advocating for illegal drug use on a school-supervised trip, which went against the school's staunch anti-drug policies. Frederick appealed to the superintendent of the school district, who adamantly upheld his suspension. He appealed his decision to the school board of the district, and they upheld his suspension. He then filed a lawsuit against the principal and school district in federal district court. Here he was seeking three things: declaratory relief, injunctive relief, and money. So the money part is simple enough to understand. The terms that you may not be so familiar with are declaratory and injunctive relief, which I'm going to try to break down. Declaratory relief, also called declaratory judgment, is when the judge in a case declares or rules on the rights, the duties, and or the obligations of the parties involved. So in this particular instance, Joseph Frederick is approaching the federal district judge, and he's asking the judge to make a declaration on the duties and obligations of perhaps himself, perhaps Deborah Morse, the principal, or perhaps even the school district. Now, I couldn't find a reliable source which said why he filed a declaratory judgment action, but if I go out on a limb, I feel like it has something to do with the fact that Deborah Morse claimed that she had a responsibility to enforce the school's anti-drug policies. So maybe Frederick approached the court and asked the judge to rule on whether or not she actually had this obligation. Next, he filed an injunctive relief action. An injunctive relief action is a little bit simpler, but it's when someone approaches the court and asks the judge to prohibit some sort of action that the petitioner wants to be prohibited. Once again, I couldn't find a solid source as to what action Frederick wanted to be prohibited, but I can only assume he wanted his suspension revoked. The federal district court refused all of those things and instead granted summary judgment to Morse and the school district. Remember from the last episode that when a judge grants summary judgment, they're basically saying one party is clearly correct and the other party is clearly incorrect, and any reasonable jury would come to this same conclusion. So to have a jury would be a waste of time. So the judge essentially said, Deborah Morse is so clearly correct and Joseph Frederick is so clearly incorrect, and any reasonable jury would come to this same conclusion, so I'm not even going to have a jury. In the federal district court's decision, the judge cited and applied the precedent set in the Supreme Court case Bethel v. Frazier instead of the Supreme Court case Tinker v. Des Moines, which is something interesting in my opinion. If you aren't aware, Tinker v. Des Moines was a landmark Supreme Court case that was decided in 1969, and it basically said that students can still enjoy the freedom of speech just like adults as long as the speech is not disrupting to the learning taking place. For the longest time after this, Tinker was used in several student speech cases until Bethel v. Frazier. Bethel v. Frazier was another Supreme Court case which not only narrowed the precedent set in Tinker, but it also narrowed the areas of free speech given to students. The ruling of Bethel held that students expressing speech on school grounds that are obscene or laced with innuendos are not protected by the First Amendment, even if this speech doesn't disrupt the learning environment. So when the judge bases his or her ruling off of Bethel and not Tinker, they're saying that they don't believe this speech is political in nature. When that judge saw the banner which read "Bong Hits for Jesus," they viewed it as obscene and not necessarily political. And do you know why he saw it that way? It's because Frederick admitted that it wasn't political. That's right, that was our tragic hero's fatal flaw. He admitted during trial proceedings that the banner was intended to be just a stupid joke, not anything political. Because of that, the judge, being a reasonable person, had no other option than to apply the precedent set in Bethel. The reason I place emphasis on this part is that, theoretically, Frederick could have just said that the banner was political, because during this time, the Alaskan state legislature was holding many referenda regarding the legalization of marijuana. However, if he had said the latter, it would have been felony perjury, so it's probably better that he told the truth. But to continue with the district court's decision, they said the banner could reasonably be interpreted as advocating for drug use, which goes against the school's anti-drug policies. With this unfortunate but expected defeat, Frederick appealed his case to the federal appellate court for the Ninth Circuit. Upon reviewing the facts of the case, the Ninth Circuit appellate court made a stunning decision. They unanimously reversed the district court's decision. They were in agreement with Frederick. On appeal, the court used the school speech doctrine to guide them towards their decision, even though Frederick was not on school grounds. The big difference now, though, is that the appellate court is looking at this case through the precedent set in Tinker rather than that set in Bethel. And with Tinker-tinted goggles, the court argues that Frederick could not have possibly been disrupting class because the entire school was across the street watching an Olympic torch relay, not in the class learning. The court also surmised that although the banner may have been funny or stupid, it was not plainly offensive, nor was it decidedly non-political. The appellate court cited the referenda regarding the legalization of weed that I mentioned earlier as evidence that the banner could be regarded as political in nature. Now it was the school district's turn to do the appealing. They appealed to the Supreme Court, and the Supreme Court granted their petition for certiorari. Now, before I get into the arguments on each side, I want to take a look at the justices so that we know who we're working with. This is another Roberts Court case, meaning we've got John Roberts as Chief Justice. Remember from last episode that he's a bit of a wild card, but tends to fall just a smidge on the conservative side of the spectrum. Going down the list, we have Associate Justice John Stevens. Stevens was nominated to be an Associate Justice in 1975 by President Gerald Ford to replace Associate Justice William Douglas. He was confirmed to the court in an impressive 98-0 vote in the Senate. Regarding free speech, Stevens shifted his views throughout the duration of his tenure in the court. Initially, he was an adamant opponent of obscene speech, but as the years went on, he became more open to the idea of the First Amendment protecting some morally questionable speech, and these views became stronger as America entered the digital age. Regarding student speech more specifically, Stevens fought hard to ensure that students were allowed the same speech rights as adults. In fact, he wrote a pretty harsh dissent on the Bethel v. Fraser case. Beyond this, however, Stevens is a pretty good example of a moderate judge. There were some issues where he voted conservatively and others where he voted liberally. Next up, we're taking a look at Associate Justice Antonin Scalia. Scalia was a nominee of the Reagan era. What happened was that Chief Justice Warren Burger announced his decision to retire, so Reagan and his team had to look for a replacement. They found their replacement in William Rehnquist. The only problem there was that Rehnquist was already an Associate Justice on the Supreme Court, so if they made him the Chief Justice, they would need someone else to fill in that Associate Justice spot. The Reagan team thought that Scalia would be the best one to do it, so in 1986, Scalia's nomination was made official. Scalia faced almost no resistance getting to the Supreme Court because the Senate Democrats fought so hard trying to block Rehnquist from becoming the Chief Justice that when he did get in, they were too exhausted to put up a fight with Scalia. So in 1986, he was confirmed to the High Court on a 98-0 vote. On the court, he was a staunch originalist, meaning he interpreted the Constitution strictly as it was, which resulted in him coming to the defense of free speech in many cases and protecting it where he could, even if he didn't like the speech. It's also worth noting he was fairly conservative during this time, on and off the court. Next on the roster is Associate Justice Anthony Kennedy. Kennedy is another Reagan-era justice who was nominated in 1987 to replace the retiring Associate Justice Lewis Powell Jr. In the Senate, he was lauded by members on both sides of the aisles and was seen as a balanced and fair moderate. This resulted in him cruising to the Associate Justice spot on a 97-0 vote of approval. Regarding the freedom of speech, Kennedy was a staunch advocate for it and desired the freedom of speech to be broad in definition and far-reaching in its power. Moving along, we have Associate Justice David Souter. George H.W. Bush nominated Souter in 1990, and Souter was a real wild card at the time because even though he had been a justice in the lower courts, he had never written any opinions on controversial topics such as gun control or abortion rights, but most speculated that he would be a conservative justice. He received a bit of opposition in the Senate, but nonetheless he was confirmed on a 90-9 vote in 1990. In his first few years as a justice, it appeared as though the speculation was right. By all accounts, Souter was a strict constructionist who tended to vote conservatively. When Clarence Thomas was appointed, though, Souter began ruling more moderately, with an even sprinkling of conservative and liberal opinions. As the years went on, Souter began finding himself amongst the liberal opinions of the court more and more, until he became a reliable liberal vote for the court. Just as his ideology changed during his time on the court, so did his views on the First Amendment. In the beginning, he was much more willing to restrict the First Amendment's power, but as he became more moderate, he seemed to question the suppression of free speech, until finally, in his later years on the court, he became much more protective of the First Amendment with regard to freedom of speech. Moving along, we have Clarence Thomas. If you recall from his introduction last episode, Clarence tends to side with the other conservative justices of the court, but is unafraid to be a lone dissenter. In dealing with the First Amendment, Thomas has upheld the First Amendment time and time again, with only a handful of outlying dissents. Next up, we have Ruth Bader Ginsburg, the infamous RBG. If you'll recall from her introduction last episode, she is considered to be the leader of the liberal wing of the court. In dealing with First Amendment cases, Ginsburg has been quick to uphold the freedom of speech, even if it places her on the dissenting side of the court. Next up is the classic Associate Justice Stephen Breyer. From his introduction last episode, you should be aware that Breyer often finds himself amongst the other liberal justices of the court. But how does he view the First Amendment's freedom of speech? Breyer has been known to truncate some of the freedoms of speech and instead put a greater gravity on the words of Congress or local law enforcement. This means that in a hypothetical case where Congress passes a bill restricting some form of speech, Breyer would be likely to uphold that congressional law. Last but not least, we have the timeless Associate Justice Samuel Alito, arguably one of the most conservative justices on the court during this case. Regarding freedom of speech, Alito tends to play it by ear on a case-by-case basis, so we're going to see what he and the other justices have to say about this particular case in just a moment. But first, I want to remind you of the constitutional questions that are being brought before the court in this case. That's right, whenever a case makes it to the Supreme Court, it's usually because it asks some interesting or unanswered constitutional questions. So one of the constitutional questions being asked in this case is, does the First Amendment allow public schools to prohibit students from displaying messages promoting the use of illegal drugs at school-supervised events? And the second question is, does a school official have qualified immunity from a damages lawsuit when, in accordance with school policy, they discipline a student for displaying a banner with a drug reference at a school-supervised event? So we've introduced the justices, we've asked the constitutional questions. I think it's time that we dive into these oral arguments. The first to enter the lion's den was Kenneth Starr, who was representing Morse in this case, and it did not take long for him to get into an exchange with Justices Souter and Kennedy. Here's an excerpt. Kennedy says, "Well, is this case limited to signs about drugs? What is the rule that you want us to adopt for deciding this case?" Starr responds, "The rule that the court articulated in Tinker. The rule of the court as articulated in Tinker is that there is, in fact, a right to political speech subject to disruption, and it requires that the speech not be disruptive." Then Justice Kennedy says, "Disruptive of what? Disruptive of the classroom order? Well, there was no classroom here." Starr says, "Including but not limited to." This was a school-authorized event. This was education outside of the classroom. It was essentially a school simply out of doors. It was essentially, and then he's cut off by Souter, who says, "Well, I can understand if they unfurled the banner in a classroom that it would be disruptive, but what did it disrupt on the sidewalk?" Starr responds, "It disrupted the educational mission of the school." Then Justice Souter says, "No, but I mean, that's a level of generality that doesn't get us very far. I mean, what specifically did it disrupt? Did it disrupt the parade? Did it disrupt teaching? What was it?" And Starr responds, 5520, a school policy of the board that says emphatically that political speech is protected, embracing Tinker. And then Souter says, "Then, if that's the rule, The school can make any rule it wants on any subject restrictive of speech, and if anyone violates it, the result is, on your reasoning, it's disruptive under Tinker. And Starr kind of defends himself. He says, not at all. I think in that form, and Sauter kind of interrupts him and says, you know what, then I'm missing the argument. So already there's a pretty uncomfortable exchange, but at this point in the oral arguments, the justices are exploring what is disruptive speech under the precedent set in Tinker. Minutes later, Sauter and Starr get into another verbal tussle over what exactly was disruptive about Frederick's sign. Starr starts off by saying, under our theory, we think she being Deborah Morse, could have interfered with that because it was disruptive to the event. It was disruptive to the event itself, but and then he's interrupted by Sauter, who says, what would be disorderly? I don't understand this disorder. If somebody holds up a sign and says, change the marijuana laws, why is it disruptive of anything? Simply because the school quite naturally has said we support the enforcement of the law, and the law right now does forbid the use of marijuana. It's political speech, it seems to me. I don't see what it disrupts, unless disruption simply means any statement of disagreeing with a position officially adopted by the school. Is that what you mean by disruption? Starr replies by saying, no, Your Honor. First of all, this is, I think, an unusual characterization, namely for this to be called political speech. After this, and more time spent fending off questions from the justices, the court begins to ask all these hypotheticals about how this case could have went differently. It starts off with Stevens saying, let me just clear up one thing to be 100% sure I understand your position. The message is the critical part of this case. If it was a totally neutral message on a 15-foot sign, that would be okay. You're not saying 15-foot signs are disruptive. Starr says, not inherently disruptive, but in fact the answer is yes. We're not saying that, and he's interrupted by Stevens, who says, and so we're focusing on the message, and that's the whole crux of the case. And Starr replies by saying, yep, that's why this case is here, because of the message. And Breyer jumps in and says, well, why is that? Why? I mean, suppose you go on a school trip and the teacher says, on the school trip, I don't want people unfurling 15-foot banners. I don't care what they're about. And Starr says, it may very well be. And then Breyer interrupts him again and says, we're going to visit the state capitol and we are not marching down the street with 15-foot banners. I mean, does the First Amendment say the teacher can't say that? Starr replies with, it does not, but the Juneau School Board and in Policy 5520, Justice Breyer allows. In fact, it has a Tinker statement in the first paragraph of 5520, which is also you will not be advocating drugs. And so there is essentially a culture of liberty in Juneau. You don't have to, and he's interrupted again by Breyer, who says, you just said suppose. Why should I not say that? I mean, I'm not going to do it necessarily, but why could I not say, would it be wrong in an opinion to say a school board can on a school trip tell the students they can't unfurl 15-foot banners? Is it a correct statement of the law or not, in your opinion? Starr says, in my opinion, it is a correct statement of the law. But in response to Justice Stevens' question, the message here is in fact critical, because what we know about this case is that, and you're here of course to respond to this case, which has to do with a message that the message interpreter, Deborah Morse, who by the way, and Stevens interrupts him and says, it's also critical here to your case that it was a school event. If this had been 2 blocks down the street, there would have been no objection. Starr responds with, if Mr. Frederick had seen fit to go down to Glacier Avenue to J&J's, a popular hangout, there would have been no high school jurisdiction. There may have been some elementary school jurisdiction, but yes, he could have gone, Justice Stevens, to the state capitol or anywhere along the 10-mile route. Ginsburg jumps in and says, suppose it were Saturday and not a school day, and the school children were not required to show up at the Olympic event, but were encouraged to, and the same thing happened. Would it make a difference that it wasn't in the course of a regular school day? Starr says, no, I think it still, under your hypothetical, would be school-sponsored, but there might be a more difficult showing of disruption or inconsistency with the educational mission. This is what this court articulated in Frazier and again in Kohlmeyer, that the school is able, under our policies of federalism and value of federalism and democratic theory, to fashion its educational mission subject to constitutional safeguards, and that mission of preventing the schools from being infected with pro-drug messages continues wherever there is school jurisdiction, and that would include on a Saturday field trip or other kind of activity. And I think that he's kind of interrupted by Scalia, who says, Mr. Starr, you responded to Justice Breyer that you think the school could just prohibit the unfurling of 15-foot banners on a trip. Could it prohibit the wearing of black armbands on a trip? And Starr says, I don't believe so. Scalia then pushes. He says, and if not, what's the difference? Starr says, because of the potential for disruption, disorderliness in the event, and the judgment that is entrusted to. He's interrupted, and arguments continue along this line until the justices come to the point that the message on the banner could be interpreted to mean different things when looked at by different people. In fact, Ruth Bader Ginsburg says, here one could look at these words and say it's just nonsense, or one could say it's like mares eat oats. It isn't clear that this is smoke pot. Starr says, Your Honor, again, Deborah Morse, a conscientious principal, interpreted the message in light of the subculture of the school where drug use is a serious problem, and it was an on-the-spot judgment. We believe that judgment was reasonable as opposed to a judgment reached in judicial chambers, but we know that that was also the judgment of the superintendent and district judge. And Justice Stevens says, is that a judgment clear enough as a matter of law, or is there a possible debate as to whether that's a reasonable interpretation of the message? Let's assume it was an ambiguous message. Would we have to accept her interpretation on summary judgment? And Starr replies, yes, I believe you do. And, well, that's of course a question for the district judge. And here the judge analyzed the fact in terms of what the individual was trying to say and determined that is a reasonable interpretation, and that is all that is required under this court's law. And after this, Starr reserves the remainder of his time and turns it over to Deputy Solicitor General Edwin Needler, who is arguing on behalf of Morse and the school district. His main argument is that schools have the right to suppress most, if not all, forms of student speech which are in contravention to that particular school's educational mission or their core set of beliefs. This upsets a lot of the justices, and they bring up points such as, well, what if his school's core beliefs is that their students should support the military? If a student comes into school wearing an anti-military article of clothing, can the school suppress that? To which Needler responds that the school cannot suppress the speech in that example because that's political speech. This riles up the justices even more, and they lament that Needler is creating all these unnecessary sections and categories of speech that can't be suppressed and speech that can be suppressed. The last example I gave isn't word for word, it was just an example to paint a picture, but here are some actual examples of the verbal altercations between Needler and the High Court. So Kennedy says, I'm asking what your recommendation is to what our rule should be in this case. And Needler replies, well, I think this is a manifestation of the principle articulated in Earls and repeated in Hazelwood that a school does not have to tolerate a message that is inconsistent with its basic educational, and he's interrupted by Alito, who says, well, I find that a very disturbing argument, because schools have and they can define their educational mission so broadly that they can suppress all sorts of political speech and speech expressing fundamental values of the students under the banner of getting rid of speech that's inconsistent with educational missions. Neither retorts, that's why I think it would make a lot of sense for the court to articulate a rule that had to do with encouraging illegal conduct, and particularly, and Breyer says, well, why go into this? I mean, that's what I actually seriously don't understand. Suppose the rule has the following rule. By the way, on our field trips, you can carry around 15-foot banners. They can say anything. Except they can't talk about drugs, and they can't talk about sex, and they can't talk about, I don't know. Or I'd say 3 things. Would that be constitutional? And Needler responds with, well, I think a school could certainly prohibit the display of banners on a school trip or in a school assembly. And Breyer says, suppose that this particular person had whispered to his next-door neighbor, bong hits for Jesus, heh heh heh, suppose that's what happened. And Needler says, and that may well be different. And Breyer retorts, no. What would be different? That's would a principal that has to act quickly sees across the street at a school meeting a big banner go up making a joke out of drug use, so the principal acts. Now, are we supposed to divide that into little bitsy parts? Because as soon as we do, we are going to get a rather interesting, complicated, and varied set of constitutional rules. But you want us to do that. And Needler says, no, I do not. I think the point that you make, that a principal sees the banner across the street and sees the word bong hits, and at that very moment when the Olympic torch was about to arrive, I think it was. She made a quick judgment, and an entirely reasonable one, that the display of the slang word bong hits, and after this, Needler is cut off, but he does mention that under Tinker, a student's speech must also be disruptive in order to be suppressed, prompting Chief Justice Roberts to ask, So you think that not a 15-foot banner, but a very discreet button that says legalize marijuana, although it might be covered as not being disruptive under Tinker, it could be inconsistent with the school's mission and prohibited on that basis. And Needler says, well, I think if the button is legalize marijuana during a referendum in the state, then that might be the category of political speech that could not be regulated. Following Needler is Frederick's counsel, Douglas Mertz, who immediately shifts the tone and perspective of this case. You always hear that when building a winning case, lawyers always try to paint some sort of picture, either of the defendant or of the plaintiff. They might point to evidence that the plaintiff is unreliable or that the defendant is an angel, and this tactic is extremely clear after hearing Morse and Frederick's counsel talk. Needler and Starr portrayed this case as one solely about drugs. They claimed that this case was between a student encouraging drug use and a principal who found the compelling need to prevent it. Mertz differs, starting in his opening statement by saying that this is a case not about drugs, but instead about free speech. A few minutes into Mertz's argument, he slips up and, in my opinion, digs himself a grave too deep to come back out of. His claim is that schools must tolerate all speech which contradicts their ideals and values as long as that speech is not disruptive, which prompts Justice Scalia to conjecture, well, but the school has a program, an anti-drug program that shows movies, it brings in policemen and social workers to preach against drug use, and you're saying that, never mind unfurling a banner, you're saying that it has to let students contradict this message it's trying to teach, to walk around, with a button that says smoke pot, it's fun. Does the school have to do that? And Mertz says, I believe, Your Honor, that's a non-disruptive pin, badge, whatever you want to call it, would have to be tolerated. However, they would not have to tolerate a student who interrupts an anti-drug presentation. And Scalia responds, but the school, even though it's trying to teach one point of view, can allow students to come in and undermine that point of view, assuming that it's legitimate to teach that point of view. It can allow students to come in and undermine what it's trying to teach, and that's not disruption in your view? Mertz defends himself. He says, I think they cannot prevent presentation of a contrary viewpoint as long as it is done in such a way that it doesn't interfere with the school's own presentation of its viewpoint. Kennedy jumps in. He says, can the student be allowed to wear a button that says rape is fun? And Mertz says, no, I don't think so. And Kennedy says, why? And Mertz says, there's a distinction there. And Kennedy says, why? And Mertz says, because when you're talking about hate speech that advocates violence, then you're in another category of speech. There has been general recognition, but he's interrupted by Scalia, who jumps in and says, non-violent crimes are okay. It's only violent crimes that you cannot promote, right? Extortion is profitable. That's okay. This is a very, very, with all respect, ridiculous line. I mean, I can understand you're saying you cannot promote things that are unlawful, but to say, oh, it's only violent? Where do you get that line from? Only violent, unlawful acts? Mertz responds that, within the context of the time, it was completely reasonable to assume that the sign could have been referencing the marijuana laws in place at the time. Stephen Breyer, though, makes a good point, and he says, what actually happened is the principal looks across the street, a 15-foot banner goes up at what's supposed to be a school event with everybody together in a single place, and it says a joke. It makes a joke out of drug use. The principal thinks, of course, adolescents and post-adolescents sometimes like to test limits, and if the kids go around having 15-foot banners making a joke out of drug use, that really does make it a little tougher for me to convince the student at this school not to use drugs, and particularly putting up 15-foot banners. I don't know why everybody wants to get away from that, because I think you would have a very different case if in fact it had been a whisper, or if it had been a serious effort to contest the drug laws. It wasn't either. It was a joke. It was a 15-foot banner. We have the message, plus the means, plus the school event. Now what's your response? And Mertz says, in fact, what it was a person displaying this banner in a quiet, passive manner that didn't interfere with anybody's observation. After that exchange, nothing too interesting occurs. It's mainly the justices and Mertz arguing over what disruption means. The justices define it as impeding the ability of a teacher to teach a lesson, as well as undermining the school's defined educational mission. Mertz, on the other hand, defines disruption just to be impeding the ability of a teacher to teach a lesson, and he claims that when a student expresses a viewpoint that's diametrically opposed to that of the school must allow it to encourage healthy debate and discussion, no matter how unwise or immature the expression may be. So, after hearing the excerpts of the oral arguments, what do the justices ultimately decide? In a razor-thin 5-4 vote, the Supreme Court overturns and reverses the decision of the Ninth Circuit Court of Appeals, effectively agreeing with Deborah Morse and the school district. Regarding the question of whether or not schools have the right to prohibit students from making expressions which promote the use of illegal drugs, the court ruled that yes, principals and school officials do indeed have the right to suppress student speech which promotes the use of narcotics. However, because they ruled that way on the first question, there is no need to rule on the second question of does the principal have qualified immunity in this lawsuit. The qualified immunity question is sort of confusing, so I'll try to break it down as best as I can. Basically, Frederick said that when he unfurled his banner, Deborah Morse should have known that he was within his First Amendment rights, and therefore her suppression of his speech was so misguided that she should have to pay out of her pocket to rectify her misdeeds. However, Morse's lawyers said that there are so many intricacies in student speech law that in the heat of the moment of telling Frederick to take his banner down, there's no way she could have known all the different facets of free speech law and different loopholes here and there. Therefore, she should not have to pay out of pocket because she's entitled to what's called qualified immunity. However, because the court ruled that Frederick was not within his free speech rights in the first place, there was no need to rule on the qualified immunity question because Deborah won the case. She doesn't have to pay anything at all. I hope that helps to clarify that, but now I want to get into these opinions. Chief Justice Roberts wrote the majority opinion, to which Justices Scalia, Kennedy, Thomas, and Alito agreed, with a concurring opinion from Justice Thomas and a separate concurring opinion from Justices Kennedy and Alito. Justice Stevens wrote a dissent joined by Justices Ginsburg and Souter. Finally, Justice Breyer wrote a concurring opinion and a dissenting opinion. Writing for the court, Justice Roberts declared, "At a school-sanctioned and school-supervised event, a high school principal saw some of her students unfurl a large banner conveying a message she reasonably regarded as promoting illegal drug use. Consistent with established school policy prohibiting such messages at school events, the principal directed the students to take down the banner. One student, among those who had brought the banner to the event, refused to do so. The principal confiscated the banner and later suspended the student. The Ninth Circuit held that the principal's actions violated the First Amendment and that the student could sue the principal for damages. Our cases make clear that students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. At the same time, we have held that the constitutional rights of students in public school are not automatically coextensive with the rights of adults in other settings, and that the rights of students must be applied in light of the special characteristics of the school environment. Consistent with these principles, we hold that the schools may take steps to safeguard those entrusted to their care from speech that can reasonably be regarded as encouraging illegal drug use. We conclude that the school officials in this case did not violate the First Amendment by confiscating the pro-drug banner and suspending the student responsible for it." On January 24, 2002, the Olympic torch relay passed through Juneau, Alaska, on its way to the Winter Games in Salt Lake City, Utah. The torchbearers were to proceed along a street in front of Juneau Douglas High School, JDHS, while school was in session. Petitioner Deborah Morse, the school principal, decided to permit staff and students to participate in the torch relay as an approved social event or class trip. Students were allowed to leave class to observe the relay from either side of the street. Teachers and administrative officials monitored the students' actions. Respondent Joseph Frederick, a JDHS senior, was late to school that day. When he arrived, he joined his friends, all but one of whom were JDHS students, across the street from the school to watch the event. Not all of the students waited patiently. Some became rambunctious, throwing plastic cola bottles and snowballs and scuffling with their classmates. As the torchbearers and the camera crews passed by, Frederick and his friends unfurled a 14-foot banner bearing the phrase "Bong hits for Jesus." The large banner was easily readable by the students on the other side of the street. Principal Morse immediately crossed the street and demanded that the banner be taken down. Everyone but Frederick complied. Morse confiscated the banner and told Frederick to report to her office, where she suspended him for 10 days. Morse later explained that she told Frederick to take the banner down because she thought it encouraged illegal drug use, in violation of established school policy. Juneau School Board Policy No. 5520 states the school board specifically prohibits any assembly or public expression that advocates the use of substances that are illegal to minors. In addition, Juneau School Board Policy Number 5850 subjects pupils who participate in approved social events and class trips to the same student conduct rules that apply during the regular school program. Frederick administratively appealed his suspension, but the Juneau School District Superintendent upheld it, limiting it to time served, 8 days. In a memorandum setting forth his reasons, the superintendent determined that Frederick had displayed his banner in the midst of his fellow students during school hours at a school-sanctioned activity. He further explained that Frederick was not disciplined because the principal of the school disagreed with his message, but because his speech appeared to advocate the use of illegal drugs. The superintendent continued, "The common sense understanding of the phrase bong hits is that it is a reference to a means of smoking marijuana. Given Frederick's inability or unwillingness to express any other credible meaning for the phrase, I can only agree with the principal and countless others who saw the banner as advocating for the use of illegal drugs. Frederick's speech was not political. He was not advocating the legalization of marijuana or promoting a religious belief. He was displaying a fairly silly message promoting illegal drug use in the midst of a school activity for the benefit of television cameras covering the torch relay. Frederick's speech was potentially disruptive to the event and clearly disruptive of and inconsistent with the school's educational mission to educate students about the dangers of illegal drugs and to discourage their use. Relying on our decision in Frazier, the superintendent concluded that the principal's actions were permissible because Frederick's banner was speech or action that intrudes upon the work of the schools. The Juneau School District Board of Education upheld the suspension. Frederick then filed suit alleging that the school board and Morse had violated his First Amendment rights. He sought declaratory and injunctive relief, unspecified compensatory damages and punitive damages, and attorney's fees. The district court granted summary judgment to the school board and Morse, ruling that they were entitled to qualified immunity and that they had not infringed Frederick's First Amendment rights. The court found that Morse reasonably interpreted the banner as promoting illegal drug use, a message that directly contravened the board's policies relating to drug abuse prevention. Under the circumstances, the court held that Morse had the authority, if not the obligation, to stop such messages at a school-sanctioned activity. The Ninth Circuit reversed, deciding that Frederick had acted during a school-authorized activity and proceeding on the basis that the banner expressed a positive sentiment about marijuana use. The court nonetheless found a violation of Frederick's First Amendment rights because the school punished Frederick without demonstrating that his speech gave rise to a risk of substantial disruption. The court further concluded that Frederick's right to display his banner was so clearly established that a reasonable principal in Morse's position would have understood that her actions were unconstitutional and that Morse was therefore not entitled to qualified immunity. We granted certiorari on 2 questions: whether Frederick had a First Amendment right to wield his banner, and if so, whether the right was so clearly established that the principal may be held liable for damages. We resolved the first question against Frederick and therefore have no occasion to reach the second. At the outset, we reject Frederick's argument that this is not a school speech case, as has every other authority to address the question. The event occurred during normal school hours. It was sanctioned by Principal Morse as an approved social event or class trip, and the school district's rules expressly provide that pupils in approved social events and class trips are subject to district rules for student conduct. Teachers and administrators were interspersed among the students and charged with supervising them. The high school band and cheerleaders performed. Frederick, standing among other JDHS students across the street from the school, directed his banner toward the school, making it plainly visible to most students. Under these circumstances, we agree with the superintendent that Frederick cannot stand in the midst of his fellow students during school hours at a school-sanctioned activity and claim he is not at school. There is some uncertainty at the outer boundaries as to when courts should apply school speech precedents, but not on these facts. The message on Frederick's banner is cryptic. It is no doubt offensive to some, perhaps amusing to others. To still others, it probably means nothing at all. Frederick himself claimed that the words were just nonsense meant to attract television cameras. But Principal Morse thought the banner would be interpreted by those viewing it as promoting illegal drug use, and that interpretation is plainly a reasonable one. As Morse later explained in a declaration, when she saw the sign, she thought that the reference to a bong hit would be widely understood by high school students and others as referring to smoking marijuana. She further believed that display of the banner would be construed by students, district personnel, parents, and others witnessing the display of the banner as advocating or promoting illegal drug use in violation of school policy. We agree with Morse. At least two interpretations of the words on the banner demonstrate that the sign advocated the use of illegal drugs. First, the phrase could be interpreted as an imperative, take bong hits, a message equivalent, as Morse explained in her declaration, to smoke marijuana or use an illegal drug. Alternatively, the phrase could be viewed as celebrating drug use. Bong hits are a good thing, or we take bong hits, and we discern no meaningful distinction between celebrating illegal drug use in the midst of fellow students and outright advocacy or promotion. The pro-drug interpretation of the banner gains further plausibility given the paucity of alternative meanings the banner might bear. The best Frederick can come up with is that the banner is meaningless and funny. The dissent similarly refers to the sign's message as curious, ambiguous, nonsense, ridiculous, obscure, silly, quixotic, and stupid. Gibberish is surely a possible interpretation of the words on the banner, but it is not the only one. And dismissing the banner as meaningless ignores its undeniable reference to illegal drugs. The dissent mentions Frederick's credible and uncontradicted explanation for the message. He just wanted to get on television. But that is the description of Frederick's motive for displaying the banner. It is not an interpretation of what the banner says. The way Frederick was going to fulfill his ambition of appearing on television was by unfurling a pro-drug banner at a school event in the presence of teachers and fellow students. Elsewhere in its opinion, the dissent emphasizes the importance of political speech and the need to foster national debate about a serious issue, as if to suggest that the banner is political speech. But not even Frederick argues that the banner conveys any sort of political or religious message. Contrary to the dissent's suggestion, this is plainly not a case about political debate over the criminalization of drug use or possession. The question thus becomes whether a principal may, consistent with the First Amendment, restrict student speech at a school event when that speech is reasonably viewed as promoting illegal drug use. We hold that she may. In Tinker, this court made clear that First Amendment rights, applied in light of special characteristics of the school environment, are available to teachers and students. Tinker involved a group of high school students who decided to wear black armbands to protest the Vietnam War. School officials learned of the plan and then adopted a policy prohibiting students from wearing armbands. When several students nonetheless wore armbands to school, they were suspended. The students sued, claiming that their First Amendment rights had been violated, and this court agreed. Tinker held that the student expression may not be suppressed unless school officials reasonably conclude that it will materially and substantially disrupt the work and discipline of the school. The essential facts of Tinker are quite stark, implicating concerns at the heart of the First Amendment. The students sought to engage in political speech, using the armbands to express their disapproval of the Vietnam hostilities and their advocacy of a truce, to make their views known and, by their example, to influence others to adopt them. Political speech, of course, is at the core of what the First Amendment is designed to protect. The only interest the court discerned underlying the school's actions was the mere desire to avoid the discomfort and unpleasantness that always accompany an unpopular viewpoint, or an urgent wish to avoid the controversy which might result from the expression. The interest was not enough to justify banning a silent, passive expression of opinion unaccompanied by any disorder or disturbance. This court's next speech case was Frazier. Matthew Frazier was suspended for delivering a speech before a high school assembly in which he employed what this court called an elaborate, graphic, and explicit sexual metaphor. Analyzing the case under Tinker, the district court and the Court of Appeals found no disruption and therefore no basis for disciplining Frazier. This court reversed, holding that the school district acted entirely within its permissible authority in imposing sanctions upon Frazier in response to his offensively lewd and indecent speech. The mode of analysis employed in Frazier is not entirely clear. The court was plainly attuned to the content of Frazier's speech, citing the marked distinction between the political message of the armbands in Tinker and the sexual content of Frazier's speech. But the court also reasoned that the school boards have the authority to determine what manner of speech in the classroom or in school assembly is inappropriate. We need not resolve this debate to decide this case. For present purposes, it is enough to distill from Frazier two basic principles. First, Frazier's holding demonstrates that the constitutional rights of students in public school are not automatically coextensive with the rights of adults in other settings. Had Frazier delivered the same speech in a public forum outside the school context, it would have been protected. In school, however, Frazier's First Amendment rights were circumscribed in light of the special characteristics of the school environment. Second, Frazier established that the mode of analysis set forth in Tinker is not absolute. Whatever approach Frazier employed, it certainly did not conduct the substantial disruption analysis prescribed by Tinker. Our most recent student speech case, Kohlmeyer, concerned expressive activities that students, parents, and members of the public might reasonably perceive to bear the imprimatur of the school. Staff members of a high school newspaper sued their school when it chose not to publish 2 of their articles. The Court of Appeals analyzed the case under Tinker, ruling in favor of the students because it found no evidence of material disruption. The Court of Appeals analyzed the case under Tinker, ruling in favor of the students because it found no evidence of material disruption to classwork or school discipline. This court reversed, holding that educators do not offend the First Amendment by exercising editorial control over the style and content of student speech in a school-sponsored expressive activities, as long as their actions are reasonably related to legitimate pedagogical concerns. Kohlmeyer does not control this case because no one would reasonably believe that Frederick's banner bore the school's imprimatur. The case is nevertheless instructive because it confirms both principles cited above. Kohlmeyer acknowledged that schools may regulate some speech even though the government could not censor similar speech outside the school. And, like Fraser, it confirms that the rule of Tinker is not the only basis for restricting student speech. Drawing on the principles applied in our student speech cases, we have held in the Fourth Amendment context that while children assuredly do not shed their constitutional rights at the schoolhouse gate, the nature of those rights is what is appropriate for children in school. In particular, the school setting requires some easing of the restrictions to which searches by public authorities are ordinarily subject. Even more to the point, these cases also recognize that deterring drug use by school children is an important, indeed perhaps compelling interest. Drug abuse can cause severe and permanent damage to health and well-being of young people. School years are the time when the physical, psychological, and addictive effects of drugs are most severe. Maturing nervous systems are more critically impaired by intoxicants than mature ones. Childhood losses in learning are lifelong and profound. Children grow chemically dependent more quickly than adults, and their record of recovery is depressingly poor. And of course the effects of a drug-infested school are visited not just upon the users, but upon the entire student body and faculty, as the educational process is disrupted. Just 5 years ago, we wrote, "The drug abuse problem among our nation's youth has hardly abated since Vernonia was decided in 1995. In fact, evidence suggests that it has only grown worse." The problem remains serious today. About half of American 12th graders have used an illicit drug, as have more than a third of 10th graders and about 1/5 of 8th graders. Nearly 1 in 4 12th graders has used an illicit drug in the past month. Some 25% of high schoolers say that they have been offered, sold, or given an illegal drug on school property within the past year. Congress has declared that part of a school's job is educating students about the dangers of illegal drug use. It has provided billions of dollars to support state and local drug prevention programs and required that schools receiving federal funds under the Safe and Drug-Free Schools and Communities Acts of 1994 certify that their drug prevention programs convey a clear and consistent message that the illegal use of drugs is wrong and harmful. Thousands of school boards throughout the country, including JDHS, have adopted policies aimed at effectuating this message. Those school boards know that peer pressure is perhaps the single most important factor leading school children to take drugs, and that students are more likely to use drugs when the norms in school appear to tolerate such behavior. Student speech celebrating illegal drug use at a school event in the presence of school administrators and teachers thus poses a particular challenge for school officials working to protect those entrusted to their care from the dangers of drug abuse. The special characteristics of the school environment and the government interest in stopping student drug abuse, reflected in the policies of Congress and myriad school boards, including JDHS, allow schools to restrict student expression that they reasonably regard as promoting illegal drug use. Tinker warned that schools may not prohibit student speech because of undifferentiated fear or apprehension of disturbance, or a mere desire to avoid the discomfort and unpleasantness that always accompany an unpopular viewpoint. The danger here is far more serious and palpable. The particular concern to prevent student drug abuse at issue here, embodied in established school policy, extends well beyond an abstract desire to avoid controversy. Petitioners urge us to adopt the broader rule that Frederick's speech is proscribable because it is plainly offensive, and that term is used in Fraser. We think this stretches Fraser too far. That case should not be read to encompass any speech that could fit under some definition of offensive. After all, much political and religious speech might be perceived as offensive to some. The concern here is not that Frederick's speech was offensive, but that it was reasonably viewed as promoting illegal drug use. Although accusing this decision of doing serious violence to the First Amendment by authorizing viewpoint discrimination, the dissent concludes that it might well be appropriate to tolerate some targeted viewpoint discrimination in this unique setting. Nor do we understand the dissent to take the position that schools are required to tolerate student advocacy of illegal drug use at school events, even if that advocacy falls short of imminent lawless action. And even the dissent recognizes that the issues here are close enough that the principal should not be held liable in damages, but should instead enjoy qualified immunity for her actions. Stripped of rhetorical flourishes, then, the debate between the dissent and this opinion is less about constitutional first principles than about whether Frederick's banner constitutes promotion of illegal drug use. We have explained our view that it does. The dissent's contrary view on that relatively narrow question hardly justifies sounding the First Amendment bugle. School principals have a difficult job, and a vitally important one. When Frederick suddenly and unexpectedly unfurled his banner, Morse had to decide to act, or not to act, on the spot. It was reasonable for her to conclude that the banner promoted illegal drug use in violation of established school policy, and that failing to act would send a powerful message to her students in her charge, including Frederick, about how serious the school was about the dangers of illegal drug use. The First Amendment does not require schools to tolerate at school events student expression that contributes to those dangers. The judgment of the United States Court of Appeals for the Ninth Circuit is reversed, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. So let's talk about the court's opinion here. Throughout it, Roberts mentions three important precedent cases: Tinker v. Des Moines, Hazelwood v. Kohlmeyer, and Bethel v. Frazier. All of these are Supreme Court cases involving some aspect of student speech and whether or not it can be suppressed. This puts the court in the position of deciding which of these cases to use to justify their decision. The precedent set in Tinker involves students expressing a political opinion in a non-disruptive manner. Roberts explains that the court didn't base their decision off of Tinker because Frederick himself said that the banner's message was not political. At best, it was silly nonsense that was meant to capture the camera's attention. The precedent set in the Hazelwood case says that schools can suppress any student-written school newspaper article if the school disagrees with it because 1. Other students and parents view the school newspaper as having the principal's seal of approval, so the principal has the power to decide what they approve of and disapprove of, and 2. Because school is a different environment from the real world and there's just no way to get around that. The school environment is one where the students must obey the teachers and principals. Therefore, a student journalist is more restricted in what they can or cannot publish. Roberts says that the court did not base their decision off of the Hazelwood case because Frederick's banner wasn't similar to a school-funded newspaper. The third case, Bethel v. Frazier, involves student speech when the student speech did not cause disruption, but was obscene and contained innuendos. The precedent set in this case said schools are allowed to suppress student speech containing innuendos because it's essentially obscene speech at that point, and the Supreme Court has ruled in the past that obscene speech is not protected under the First Amendment. Roberts said the court based their decision off the Bethel case because Frederick's vague yet drug-related message most closely fit the vague, double entendre-filled speech which Frazier gave. In his concurring opinion, Justice Thomas said, "The court today decides that a public school may prohibit speech advocating illegal drug use. I agree and therefore join its opinion in full. I write separately to state my view that the standard set forth in Tinker v. Des Moines Independent Community School District is without basis in the Constitution. The First Amendment states that Congress shall make no law abridging the freedom of speech. As this court has previously observed, the First Amendment was not originally understood to permit all sorts of speech. Instead, there are certain well-defined and narrowly limited classes of speech, the prevention and punishment of which have never been thought to raise any constitutional problem. In my view, the history of public education suggests that the First Amendment, as originally understood, does not protect student speech in public schools. Although colonial schools were exclusively private, public education proliferated in the early 1800s. By the time the states ratified the 14th Amendment, public schools had become relatively common. If students in public schools were originally understood as having free speech rights, one would have expected 19th century public schools to have respected those rights and courts to have enforced them. They did not. During the colonial era, private schools and tutors offered the only educational opportunities for children, and teachers managed classrooms with an iron hand. Public schooling arose in part as a way to educate those too poor to afford private schools. Because public schools were initially created as substitutes for private schools, when states developed public education systems in the early 1800s, no one doubted the government's ability to educate and discipline children as private schools did. Like their private counterparts, early public schools were not places for freewheeling debates or exploration of competing ideas. Rather, teachers instilled a core of common values in students and taught them self-control. Teachers instilled these values not only by presenting ideas, but also through strict discipline. Schools punished students for behavior the school considered disrespectful or wrong. Rules of etiquette were enforced, and courteous behavior was demanded. To meet their educational objectives, schools required absolute obedience. In short, in the earliest public schools, teachers taught and students listened. Teachers commanded and students obeyed. Teachers did not rely solely on the power of ideas to persuade, they relied on discipline to maintain order. Through the legal doctrine of in loco parentis, courts upheld the rights of schools to discipline students, to enforce rules, and to maintain order. Rooted in the English common law, in loco parentis originally governed the legal rights and obligations of tutors in private schools. Chancellor James Kent noted the acceptance of the doctrine as part of American law in the early 19th century. As early as 1837, state courts applied the in loco parentis principle to public schools. One of the most sacred duties of parents is to train up and qualify their children for becoming useful and virtuous members of society. This duty cannot be effectually performed without the ability to command obedience, to control stubbornness, to quicken diligence, and to reform bad habits. The teacher is the substitute of the parent, and in the exercise of these delegated duties is invested with his power. Applying in loco parentis, the judiciary was reluctant to interfere in the routine business of school administration, allowing schools and teachers to set and enforce rules and to maintain order. Thus, in the early years of public schooling, schools and teachers had considerable discretion in disciplinary matters. To accomplish the desirable ends of teaching self-restraint, obedience, and other civic virtues, the master of the school is necessarily invested with much discretionary power. He must govern these pupils, quicken the slothful, spur the indolent, restrain the impetuous, and control the stubborn. He must make rules, give commands, and punish disobedience. What rules, what commands, and what punishments shall be imposed are necessarily largely within the discretion of the master, where none are defined by the school board. A review of the case law shows that in loco parentis allowed schools to regulate student speech as well. Courts routinely preserve the rights of teachers to punish speech that the school or teacher thought was contrary to the interests of the school and its educational goals. For example, the Vermont Supreme Court upheld the corporal punishment of a student who called his teacher Old Jack Seaver in front of other students. The court explained its decision as follows: language used to other scholars to stir up disorder and subordination, or to heap odium and disgrace upon the master, writings and pictures placed so as to suggest evil and corrupt language, images and thoughts to the youth who must frequent the school, all such or similar acts tend directly to impair the usefulness of the school, the welfare of the scholars, and the authority of the master. By common consent and by the universal custom in our New England schools, the master has always been deemed to have the right to punish such offenses. Such power is essential to the preservation of order, decency, decorum, and good government in schools. Similarly, the California Court of Appeals upheld the expulsion of a student who gave a speech before the student body that criticized the administration for having an unsafe building because of the possibility of fire. The punishment was appropriate, the court stated, because the speech was intended to discredit and humiliate the board in the eyes of the students, and tended to impair the discipline of the school. Likewise, the Missouri Supreme Court explained that a rule which forbade the use of profane language and quarreling was not only reasonable, but necessary to the orderly conduct of the school, and the Indiana Supreme Court upheld the punishment of a student who made distracting demonstrations in class for a breach of good deportment. The doctrine of in loco parentis limited the ability of schools to set rules and control their classrooms in almost no way. It merely limited the imposition of excessive physical punishment. In this area, the case law was split. One line of cases specified that punishment was wholly discretionary as long as the teacher did not act with legal malice or cause permanent injury. Another line allowed courts to intervene where the corporal punishment was clearly excessive. Under both lines of cases, courts struck down only punishments that were excessively harsh. They almost never questioned the substantive restrictions on student conduct set by teachers in schools. Tinker effected a sea change in students' speech rights, extending them well beyond traditional bounds. The case arose when a school punished several students for wearing black armbands to school to protest the Vietnam War. Determining that the punishment infringed the students' First Amendment rights, this court created a new standard for students' freedom of speech in public schools, where there is no finding and no showing that engaging in the forbidden conduct would materially and substantially interfere with the requirements of appropriate discipline in the operation of the school. The prohibition cannot be sustained. Accordingly, unless a student's speech would disrupt the educational process, students had a fundamental right to speak their minds or wear their armbands, even on matters the school disagreed with or found objectionable. Justice Black dissented, criticizing the court for subjecting all the public schools in the country to the whims and caprices of their loudest-mouthed but maybe not their brightest students. He emphasized the instructive purpose of schools. Taxpayers send children to school on the premise that at their age they need to learn, not teach. In his view, the court's decision surrendered control of the American public school system to public school students. Of course, Tinker's reasoning conflicted with the traditional understanding of the judiciary's role in relation to public schooling, a role limited by in loco parentis. Perhaps for that reason, the court has since scaled back Tinker's standard, or rather set the standard aside on an ad hoc basis. In Bethel v. Frazier, a public school suspended a student for delivering a speech that contained an elaborate, graphic, and explicit sexual metaphor. The Court of Appeals found that the speech caused no disruption under the Tinker standard, and this court did not question that holding. The court nonetheless permitted the school to punish the student because of the objectionable content of his speech. Signaling at least a partial break with Tinker, Frazier left the regulation of indecent student speech to local schools. Similarly, in Hazelwood School District v. Kohlmeyer, the court made an exception to Tinker for school-sponsored activities. The court characterized newspapers and similar school-sponsored activities as part of the school curriculum and held that educators are entitled to exercise greater control over these forms of student expression. Accordingly, the court expressly refused to apply Tinker's standard. Instead, for school-sponsored activities, the court created a new standard that permitted school regulations of student speech that are reasonably related to legitimate pedagogical concerns. Today, the court creates another exception. In doing so, we continue to distance ourselves from Tinker, but we neither overrule it nor offer an explanation of when it operates and when it does not. I am afraid that our jurisprudence now says that students have a right to speak in schools except when they don't, a standard continuously developed through litigation against local schools and their administrators. In my view, petitioners could prevail for a much simpler reason. As originally understood, the Constitution does not afford students a right to free speech in public schools. In light of the history of American public education, it cannot seriously be suggested that the First Amendment freedom of speech encompasses a student's right to speak in public schools. Early public schools gave total control to the teachers, who expected obedience and respect from students, and courts routinely deferred to schools' authorities to make rules and to discipline students for violating these rules. Several points are clear. 1. Under in loco parentis, speech rules and other school rules were treated identically. 2. The in loco parentis doctrine imposed almost no limit on the types of rules that a school could set while students were in school. And 3. Schools and teachers had tremendous discretion in imposing punishments for violations of those rules. It might be suggested that the early school speech cases dealt only with slurs and profanity, but that criticism does not withstand scrutiny. First, state courts repeatedly reasoned that schools had discretion to impose discipline to maintain order. The substance of the student's speech or conduct played no part in the analysis. Second, some cases involved punishment for speech on weightier matters, for instance, a speech criticizing school administrators for creating a fire hazard. Yet courts refused to find an exception to in loco parentis even for this advocacy of public safety. To be sure, our educational system faces administrative and pedagogical challenges, different from those faced by 19th century schools, and the idea of treating children as though it were still the 19th century would find little support today. But I see no constitutional imperative requiring public schools to allow all student speech. Parents decide whether to send their children to public schools. If parents do not like the rules imposed by those schools, they can seek redress in school boards or legislatures. They can send their children to private schools or homeschool them, or they can simply move. Whatever rules apply to student speech in public schools, those rules can be challenged by parents in the political process. In place of that democratic regime, Tinker substituted judicial oversight of the day-to-day affairs of the public schools. The Tinker Court made little attempt to ground its holding in the history of education or in the original understanding of the First Amendment. Instead, it imposed a new and malleable standard. Schools could not inhibit student speech unless it substantially interfered with the requirements of appropriate discipline in the operation of the school. Inherent in the application of that standard are judgment calls about what constitutes interference and what constitutes appropriate discipline. Historically, courts reasoned that only local school districts were entitled to make those calls. The Tinker Court usurped that traditional authority for the judiciary. And because Tinker utterly ignored the history of public education, courts, including this one, routinely find it necessary to create ad hoc exceptions to its central premise. This doctrine of exceptions creates confusion without fixing the underlying problem by returning to first principles. Just as I cannot accept Tinker's standard, I cannot subscribe to Kohlmeyer's alternative. Local school boards, not the courts, should determine what pedagogical interests are legitimate and what rules reasonably relate to those interests. Justice Black may not have been a prophet or the son of a prophet, but his dissent in Tinker has proved prophetic. In the name of the First Amendment, Tinker has undermined the traditional authority of teachers to maintain order in public schools. Once a society that generally respected the authority of teachers, deferred to their judgment, and trusted them to act in the best interest of schoolchildren, we now accept defiance, disrespect, and disorder as daily occurrences in many of our public schools. We need look no further than this case for an example. Frederick asserts a constitutional right to utter at a school event what is either gibberish or an open call to use illegal drugs. To elevate such impertinence to the status of constitutional protection would be farcical and would indeed be to surrender control of the American public school system to public school students. I join the court's opinion because it erodes Tinker's hold in the realm of student speech, even though it does so by adding to the patchwork of exceptions to the Tinker standard. I think the better approach is to dispense with Tinker altogether, and given the opportunity, I would do so. Wow. So, obviously, a very hot take from Justice Thomas there. Not only is he saying that Frederick's speech is not protected by the First Amendment, he's saying no student speech is protected by the First Amendment. He wants to overturn the precedent set in Tinker and strip students of their freedom of speech. Obviously, you can probably understand how I feel about that idea, but I'll elaborate later. I do want to keep reading these opinions, though, and the next opinion is a concurrence from Justices Alito and Kennedy, who said, I join the opinion of the court on the understanding that A, it goes no further than to hold that a public school may restrict speech that a reasonable observer would interpret as advocating illegal drug use, and B, it provides no support for any restriction of speech that can plausibly be interpreted as commenting on any political or social issue, including speech on issues such as the wisdom of the war on drugs or of legalizing marijuana for medicinal use. The opinion of the court correctly reaffirms the recognition in Tinker v. Des Moines of the fundamental principle that students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. The court is also correct in noting that Tinker, which permits the regulation of student speech that threatens a concrete and substantial disruption, does not set out the only ground on which in-school student speech may be regulated by state actors in a way that would not be constitutional in other settings. But I do not read the opinion to mean that there are necessarily any grounds for such regulation that are not already recognized in the holdings of this court. In addition to Tinker, the decision in the present case allows the restriction of speech advocating illegal drug use. Bethel v. Frazier permits the regulation of speech that is delivered in a lewd or vulgar manner as part of a middle school program, and Hazelwood v. Kohlmeyer allows a school to regulate what is in essence the school's own speech, that is, articles that appear in a publication that is an official school organ. I join the opinion of the court on the understanding that the opinion does not hold that the special characteristics of the public schools necessarily justify any other speech restrictions. The opinion of the court does not endorse the broad argument advanced by petitioners and the United States that the First Amendment permits public school officials to censor any student speech that interferes with the school's educational mission. This argument can easily be manipulated in dangerous ways, and I would reject it before such abuse occurs. The educational mission of the public schools is defined by the elected and appointed public officials with authority over the schools and by the school administrators and faculty. As a result, some public schools have defined their educational missions as including the inculcation of whatever political and social views are held by the members of these groups. During the Tinker era, a public school could have defined its educational mission to include solidarity with our soldiers and their families, and thus could have attempted to outlaw the wearing of black armbands on the ground that they undermined this mission. Alternatively, a school could have defined its educational mission to include the promotion of world peace and could have sought to ban the wearing of buttons expressing support for the troops on the ground that the buttons signified approval of war. The educational mission argument would give public school authorities a license to suppress speech on political and social issues based on disagreement with the viewpoint expressed. The argument therefore strikes at the very heart of the First Amendment. The public schools are invaluable and beneficent institutions, but they are, after all, organs of the state. When public school authorities regulate student speech, they act as agents of the state. They do not stand in the shoes of the students as parents. It is a dangerous fiction to pretend that parents simply delegate their authority, including their authority to determine what their children may say and hear, to public school authorities. It is even more dangerous to assume that such a delegation of authority somehow strips public school authorities of their status as agents of the state. Most parents realistically have no choice but to send their children to a public school, and little ability to influence what occurs in the school. It is therefore wrong to treat public school officials, for purposes relevant to the First Amendment, as if they were private, non-governmental actors standing in loco parentis. For these reasons, any argument for altering the usual free speech rules in the public schools cannot rest on a theory of delegation, but must instead be based on some special characteristic of the school setting. The special characteristic that is relevant in this case is the threat to the physical safety of students. School attendance can expose students to threats to their physical safety that they would not otherwise face. Outside of school, parents can attempt to protect their children in many ways and may take steps to monitor and exercise control over the persons with whom their children associate. Similarly, students, when not in school, may be able to avoid threatening individuals and situations. During school hours, however, parents are not present to provide protection and guidance, and students' movements and their ability to choose the persons with whom they spend time are severely restricted. Students may be compelled on a daily basis to spend time at close quarters with other students who may do them harm. Experience shows that schools can be places of special danger. In most settings, the First Amendment strongly limits the government's ability to suppress speech on the grounds that it presents a threat of violence. But due to the special features of the school environment, school officials must have greater authority to intervene before speech leads to violence. And in most cases, Tinker's substantial disruption standard permits school officials to step in before actual violence erupts. Speech advocating illegal drug use poses a threat to student safety that is just as serious, if not always as immediately obvious. As we have recognized in the past, and as the opinion of the court today details, illegal drug use presents a grave and in many ways unique threat to the physical safety of students. I therefore conclude that public schools may ban speech advocating illegal drug use, but I regard such regulation as standing at the far reaches of what the First Amendment permits. I join the opinion of the court with the understanding that the opinion does not endorse any further extension. So, in that opinion, Alito and Kennedy are kind of taking a very cautious approach. They're tiptoeing over the minefield of student speech controversy and saying, look, the only speech schools can regulate is speech which advocates for illicit drug use. This case does not speak to any other type of speech, only, with an emphasis on only, student speech advocating for illegal drug use, which is a very narrow portion of speech, but I can only imagine that that was the desired effect. I think Alito and Kennedy were trying to preserve as much of the First Amendment extensions to students as possible. Now it's time for us to dive into the dissents. The first is from Justice Stevens, who wrote, "A significant fact barely mentioned by the court sheds a revelatory light on the motives of both the students and the principal of Juneau Douglas High School, JDHS. On January 24, 2002, the Olympic Torch Relay gave those Alaska residents a rare chance to appear on national television. As Joseph Frederick repeatedly explained, he did not address the curious message, 'Bong hits for Jesus,' to his fellow students. He just wanted to get the camera crew's attention. Moreover, concern about a nationwide evaluation of the conduct of the JDHS student body would have justified the principal's decision to remove an attention-grabbing 4-foot banner, even if it had merely proclaimed 'Glaciers Melt.' I agree with the court that the principal should not be held liable for pulling down Frederick's banner. I would hold, however, that the school's interest in protecting its students from exposure to speech, reasonably regarded as promoting illegal drug use, cannot justify disciplining Frederick for his attempt to make an ambiguous statement to a television audience, simply because it contained an oblique reference to drugs. The First Amendment demands more, indeed much more. The court holds otherwise only after laboring to establish two uncontroversial propositions. First, that the constitutional rights of students in school settings are not coextensive with the rights of adults, and second, that deterring drug use by school children is a valid and terribly important interest. As to the first, I take the court's point that the message on Frederick's banner was not necessarily protected speech, even though it unquestionably would have been had the banner been unfurled elsewhere. As to the second, I am willing to assume that the court is correct that the pressing need to deter drug use supports JDHS's rule prohibiting willful conduct that expressly advocates the use of substances that are illegal to minors. But it is a gross non sequitur to draw from these two unremarkable propositions the remarkable conclusion that the school may suppress student speech that was never meant to persuade anyone to do anything. In my judgment, the First Amendment protects student speech if the message itself neither violates a permissible rule nor expressly advocates conduct that is illegal and harmful for students. This nonsense banner does neither, and the court does serious violence to the First Amendment in upholding, indeed lauding, a school's decision to punish Frederick for expressing a view with which it disagreed. In December 1965, we were engaged in a controversial war, a war that divided this country as few other issues ever have. Having learned that some students planned to wear black armbands as a symbol of opposition to the country's involvement in Vietnam, officials of the Des Moines Public School District adopted a policy calling for the suspension of any student who refused to remove the armband. As we explained when we considered the propriety of that policy, the school officials banned and sought to punish petitioners for a silent, passive expression of opinion unaccompanied by any disorder or disturbance on the part of petitioners. The district justified its censorship on the ground that it feared that the expression of a controversial and unpopular opinion would generate disturbances. Because the school officials had insufficient reason to believe that those disturbances would materially and substantially interfere with the requirements of discipline in the operation of the school, we found the justification for the rule to lack any foundation and therefore held that the censorship violated the First Amendment. Justice Harlan dissented, but not because he thought the school district could censor a message with which it disagreed. Rather, he would have upheld the district's rule only because the students never cast doubt on the district's anti-disruption justification by proving that the rule was motivated by other than legitimate school concerns. For example, a desire to prohibit the expression of an unpopular viewpoint while permitting expression of the dominant opinion. Two cardinal First Amendment principles animate both the court's opinion in Tinker and Justice Harlan's dissent. First, censorship based on the content of the speech, particularly censorship that depends on the viewpoint of the speaker, is subject to the most righteous burden of justification. First, censorship based on the content of speech, particularly censorship that depends on the viewpoint of the speaker, is subject to the most rigorous burden of justification. Discrimination against speech because of its message is presumed to be unconstitutional. When the government targets not subject matter but particular views taken by speakers on a subject, the violation of the First Amendment is all the more blatant. Viewpoint discrimination is thus an egregious form of content discrimination. The government must abstain from regulating speech when the specific motivating ideology or the opinion or perspective of the speaker is the rationale for the restriction. Second, punishing someone for advocating illegal conduct is constitutional. Punishing someone for advocating illegal conduct is constitutional only when the advocacy is likely to provoke the harm that the government seeks to avoid. However necessary it may be to modify those principles in the school setting, Tinker affirmed their continuing vitality. As other federal courts have long recognized under Tinker, regulation of student speech is generally permissible only when the speech would substantially disrupt or interfere with the work of the school or the rights of other students. Tinker requires a specific and significant fear of disruption, not just some remote apprehension of disturbance. Yet today the court fashions a test that trivializes the two cardinal principles upon which Tinker rests. The court's test invites stark viewpoint discrimination. In this case, for example, the principal has unabashedly acknowledged that she disciplined Frederick because she disagreed with the pro-drug viewpoint she ascribed to the message on the banner, a viewpoint, incidentally, that Frederick has disavowed. Unlike our recent decision in Tennessee Secondary School Athletic Association v. Brentwood Academy, the court's holding in this case strikes at the heart of the First Amendment because it upholds a punishment meted out on a basis of a listener's disagreement with her understanding, or more likely misunderstanding, of the speaker's viewpoint. If there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. It is also perfectly clear that promoting illegal drug use comes nowhere close to the proscribable incitement of imminent lawless action. Encouraging drug use might well increase the likelihood that a listener will try an illegal drug, but that hardly justifies censorship. Every denunciation of existing law tends in some measure to increase the probability that there will be a violation of it. Condemnation of a breach enhances the probability. Expressions of approval add to the probability. Advocacy of law-breaking heightens it still further, but even advocacy of violation, however reprehensible morally, is not a justification for denying free speech where the advocacy falls short of incitement and there is nothing to indicate that the advocacy would be immediately acted upon. No one seriously maintains that drug advocacy, much less Frederick's ridiculous sign, comes within the vanishingly small category of speech that can be prohibited because of its feared consequences. Such advocacy, to borrow from Justice Holmes, has no chance of starting a present conflagration. The court rejects outright these twin foundations of Tinker because, in its view, the unusual importance of protecting children from the scourge of drugs supports a ban on all speech in the school environment that promotes illegal drug use. Whether or not such a rule is sensible as a matter of policy, carving out pro-drug speech for uniquely harsh treatment finds no support in our case law and is inimical to the values protected by the First Amendment. I will nevertheless assume for the sake of argument that the school's conceitedly powerful interest in protecting its students adequately supports its restriction on any assembly or public expression that advocates the use of substances that are illegal to minors. Given that the relationship between schools and students is custodial and tutelary, permitting a degree of supervision and control that cannot be exercised over free adults, it might well be appropriate to tolerate some targeted viewpoint discrimination in this unique setting. And while conventional speech may be restricted only when likely to incite imminent lawless action, it is possible that our rigid imminence requirement ought to be relaxed at the schools. The constitutional rights of students in public school are not automatically coextensive with the rights of adults in other settings. But it is one thing to restrict speech that advocates drug use. It is another thing entirely to prohibit an obscure message with a drug theme that a third party, subjectively and not very reasonably, thinks is tantamount to express advocacy. Even the school recognizes the paramount need to hold the line between, on the one hand, non-disruptive speech that merely expresses a viewpoint that is unpopular or contrary to the school's preferred message, and on the other hand, advocacy of an illegal or unsafe course of conduct. The district's prohibition of drug advocacy is a gloss on a more general rule that is otherwise quite tolerant of non-disruptive student speech. Students will not be disturbed in the exercise of their constitutionally guaranteed rights to assemble peaceably and to express ideas and opinions, privately or publicly, provided that their activities do not infringe on the rights of others and do not interfere with the operation of the educational program. The board will not permit the conduct on school premises of any willful activity that interferes with the orderly operation of the educational program or offends the rights of others. The board specifically prohibits any assembly or public expression that advocates the use of substances that are illegal to minors. There is absolutely no evidence that Frederick's banners reference to drug paraphernalia willfully infringed on anyone's rights or interfered with any of the school's educational programs. On its face, then, the rule gave Frederick a wide berth to express his ideas and opinions, so long as they did not amount to advocacy of drug use. If the school's rule is, by hypothesis, a valid one, it is valid only insofar as it scrupulously preserves adequate space for constitutionally protected speech. When First Amendment rights are at stake, a rule that sweeps in a great variety of conduct under a general and indefinite characterization may not leave too wide a discretion in establish some likely connection between the armbands and their feared consequences, so too JDHS must show that Frederick's supposed advocacy stands a meaningful chance of making otherwise abstemious students try marijuana. But instead of demanding that the school make such a showing, the court punts. Figuring out just how it punts is tricky. The mode of analysis it employs is not entirely clear. On occasion, the court suggests it is deferring to the principal's reasonable judgment that Frederick's sign qualified as drug advocacy. At other times, the court seems to say that it thinks the banner's message constitutes express advocacy. Either way, its approach is indefensible. To the extent the court defers the principal's ostensibly reasonable judgment, it abdicates its constitutional responsibility. The beliefs of third parties, reasonable or otherwise, have never dictated which messages amount to proscribable advocacy. Indeed, it would be a strange constitutional doctrine that would allow the prohibition of only the narrowest category of speech advocating unlawful conduct, yet would permit a listener's perceptions to determine which speech deserved constitutional protection. Such a peculiar doctrine is alien to our case law. In Abrams v. United States, this court affirmed the conviction of a group of Russian rebels, revolutionists, and anarchists on the ground that the leaflets they distributed were thought to incite, provoke, and encourage resistance to the United States. Yet Justice Holmes's dissent, which has emphatically carried the day, never inquired into the reasonableness of the United States' judgment that the leaflets would likely undermine the war effort. The dissent instead ridiculed that judgment. Nobody can suppose that the surreptitious publishing of a silly leaflet by an unknown man, without more, would present any immediate danger that its opinions would hinder the success of the government arms or have any appreciable tendency to do so. In Thomas v. Collins, we overturned the conviction of a union organizer who violated a restraining order forbidding him from exhorting workers. In so doing, we held that the distinction between advocacy and incitement could not depend on how one of those workers might have understood the organizer's speech. That would put the speaker in these circumstances wholly at the mercy of the varied understanding of his hearers and consequently of whatever inference may be drawn as to his intent and meaning. In Cox v. Louisiana, we vacated a civil rights leader's convictions for disturbing the peace, even though a Baton Rouge sheriff had deemed the leader's appeal to students to sit in at the lunch counters to be inflammatory. We never asked if the sheriff's in-person, on-the-spot judgment was reasonable. Even in Frazier, we made no inquiry into whether the school administrators reasonably thought the student's speech was obscene or profane. We rather satisfied ourselves that the pervasive sexual innuendo in Frazier's speech was plainly offensive to both teachers and students, indeed to any mature person. To the extent the court independently finds that Bong Hits for Jesus objectively amounts to the advocacy of illegal drug use, in other words that it can most reasonably be interpreted as such, the conclusion practically refutes itself. This is a nonsense message, not advocacy. The court's feeble effort to divine its hidden meaning is strong evidence of that. Frederick's credible and uncontradicted explanation for the message, he just wanted to get on television, is also relevant because a speaker who does not intend to persuade his audience can hardly be said to be advocating anything. But most importantly, it takes real imagination to read a cryptic message, the court's characterization, not mine, with a slanting drug reference as an incitement to drug use. Admittedly, some high school students, including those who use drugs, are dumb. Most students, however, do not shed their brains at the schoolhouse gate, and most students know dumb advocacy when they see it. The notion that the message on this banner would actually persuade either the average student or even the dumbest one to change his or her behavior is most implausible. That the court believes such a silly message can be proscribed as advocacy underscores the novelty of its position and suggests that the principle it articulates has no stopping point. Even if advocacy could somehow be wedged into Frederick's obtuse reference to marijuana, that advocacy was at best subtle and ambiguous. There is abundant precedent, including another opinion the Chief Justice announces today, for the proposition that when the First Amendment is implicated, the tie goes to the speaker, and that when it comes to defining what speech qualifies as the functional equivalent of express advocacy, we give the benefit of the doubt to speech, not censorship. If this were a close case, the tie would have to go to Frederick's speech, not the principal's strained reading of his quixotic message. Among other things, the court's ham-handed categorical approach is deaf to the constitutional imperative to permit unfettered debate, even among high school students, about the wisdom of the war on drugs or of legalizing marijuana for medicinal use. If Frederick's stupid reference to marijuana can, in the court's view, justify censorship, then high school students everywhere could be forgiven for zipping their mouths about drugs at schools, lest some reasonable observer censor and then punish them for promoting drugs. Consider, too, that the school district's rule draws no distinction between alcohol and marijuana, but applies even-handedly to all substances that are illegal to minors. Given the tragic consequences of teenage alcohol consumption, drinking causes far more fatal accidents than the misuse of marijuana. The school district's interest in deterring teenage alcohol use is at least comparable to its interest in preventing marijuana use. Under the court's reasoning, must the First Amendment give way whenever a school seeks to punish a student for any speech mentioning beer, or indeed anything else that might be deemed risky to teenagers? Well, I find it hard to believe that the court would support punishing Frederick for flying a "Wine Sips for Jesus" banner, which could quite reasonably be construed either as a protected religious message or as a pro-alcohol message, the breathtaking sweep of its opinion suggests it would. Although this case began with a silly, nonsensical banner, it ends with the court inventing out of whole cloth a special First Amendment rule permitting the censorship of any student speech that mentions drugs, at least so long as someone could perceive that speech to contain a latent pro-drug message. Our First Amendment jurisprudence has identified some categories of expression that are less deserving of protection than others: fighting words, obscenity, and commercial speech, to name a few. Rather than reviewing our opinions discussing such categories, I mention two personal recollections that have no doubt influenced my conclusion that it would be profoundly unwise to create special rules for speech about drug use and alcohol use. The Vietnam War is remembered today as an unpopular war. During its early stages, however, the dominant opinion that Justice Harlan mentioned in his Tinker dissent regarded opposition to the war as unpatriotic, if not treason. The dominant opinion strongly supported the prosecution of several of those who demonstrated in Grant Park during the 1968 Democratic Convention in Chicago, and the vilification of vocal opponents of the war like Julian Bond. In 1965, when the Des Moines students wore their armbands, the school districts feared that they might start an argument or cause a disturbance was well-founded. Given the context, there is special force to the court's insistence that our Constitution says we must take that risk, and our history says that it is this sort of hazardous freedom, this kind of openness, that is the basis of our national strength and of the independence and vigor of Americans who grow up and live in this relatively permissive, often disputatious society. As we now know, the then dominant opinion about the Vietnam War was not etched in stone. Reaching back still further, the current dominant opinion supporting the war on drugs in general and our anti-marijuana laws in particular is reminiscent of the opinion that supported the nationwide ban on alcohol consumption when I was a student. While alcoholic beverages are now regarded as ordinary articles of commerce, their use was then condemned with the same moral fervor that now supports the war on drugs. The ensuing change in public opinion occurred much more slowly than the relatively rapid shift in Americans' views on the Vietnam War, and progressed on a state-by-state basis over a period of many years. But just as prohibition in the 1920s and early 1930s was secretly questioned by thousands of otherwise law-abiding patrons of bootleggers and speakeasies, today the actions of literally millions of otherwise law-abiding users of marijuana and of the majority of voters in each of the several states that tolerate medicinal uses of the product lead me to wonder whether the fear of disapproval by those in the majority is silencing opponents of the war on drugs. Surely our national experience with alcohol should make us wary of dampening speech suggesting, however inarticulately, that it would be better to tax and regulate marijuana than to persevere in a futile effort to ban its use entirely. Even in high school, a rule that permits only one point of view to be expressed is less likely to produce correct answers than the open discussion of countervailing views. In the national debate about a serious issue, it is the expression of the minority's viewpoint that most demands the protection of the First Amendment. Whatever the better policy may be, a full and frank discussion of the costs and benefits of the attempt to prohibit the use of marijuana is far wiser than suppression of speech because it is unpopular. I respectfully dissent. So in his dissent, Justice Stevens came out against the majority opinion from multiple angles. First, he said that Deborah Morse is entitled to qualified immunity, whereas the majority opinion decided not to answer that question. Next, he really hammers home the idea that Frederick's message was ambiguous and stupid and nonsensical and all the other words he used to describe it, but none of it was censorable in his opinion. He also relates the ambiguity of the banner's message back to the Tinker test by saying that no reasonable student would view Frederick's message and be compelled to use marijuana, which I thought was an interesting point to at least think about. Also, towards the end of his dissent, Stevens starts to go on somewhat of a tangent talking about how even if Frederick's speech was advocating the use of illicit drugs, it's better to allow controversial speech and invite the open discussion than to stifle the expression of new ideas. The final opinion is a dissent in one part and a concurrence in another part authored by Justice Breyer. He says, "This court need not and should not decide this difficult First Amendment issue on the merits. Rather, I believe that it should simply hold that qualified immunity bars the student's claim for monetary damages and say no more. Resolving the First Amendment question presented in this case is, in my view, unwise and unnecessary. In part, that is because the question focuses upon specific content narrowly defined. May a school board punish students for speech that advocates drug use, and if so, when? At the same time, the underlying facts suggest that the Principal Morse acted as she did not simply because of the specific content and viewpoint of Joseph Frederick's speech, but also because of the surrounding context and manner in which Frederick expressed his views. To say that school officials might reasonably prohibit students during school-related events from unfurling 14-foot banners with any kind of irrelevant or inappropriate message designed to attract attention from television cameras seems unlikely to undermine basic First Amendment principles. But to hold, as the court does, that schools may take steps to safeguard those entrusted to their care from speech that can reasonably be regarded as encouraging illegal drug use, and that schools may restrict student expression that they reasonably regard as promoting illegal drug use, is quite a different matter. This holding, based as it is on viewpoint restrictions, raises a host of serious concerns. One concern is that while the holding is theoretically limited to speech promoting the use of illegal drugs, it could in fact authorize further viewpoint-based restrictions. Illegal drugs, after all, are not the only illegal substances. What about encouraging the underage consumption of alcohol? Moreover, it is unclear how far the court's rule regarding the drug advocacy extends. What about a conversation during the lunch period where one student suggests that glaucoma sufferers should smoke marijuana to relieve the pain? What about deprecating commentary about an anti-drug film shown in school? And what about drug messages mixed with other, more expressly political content? If, for example, Frederick's banner had read, "Legalize bong hits," he might be thought to receive protection from the majority's rule, which goes to speech encouraging illegal drug use. But speech advocating change in drug laws might also be perceived of as promoting the disregard of existing drug laws. Legal principles must treat like instances alike. Those principles do not permit treating drug use separately without a satisfying explanation of why drug use is sui generis. To say that illegal drug use is harmful to students, while surely true, does not itself constitute a satisfying explanation because there are many such harms. During a real war, one less metaphorical than the war on drugs, the court declined an opportunity to draw narrow subject matter-based lines. We should decline this opportunity today. Although the dissent avoids some of the majority's pitfalls, I fear that, if adopted as law, it would risk significant interference with reasonable school efforts to maintain discipline. What is a principal to do when a student unfurls a 14-foot banner carrying an irrelevant or inappropriate message during a school-related event in an effort to capture the attention of television cameras? Nothing? In my view, a principal or a teacher might reasonably view Frederick's conduct in this setting as simply beyond the pale, and a school official, knowing that adolescents often test the outer boundaries of acceptable behavior, may believe it is important for the offending student and his classmates to establish when a student has gone too far. Neither can I simply say that Morse may have taken the right action, confiscating Frederick's banner, but for the wrong reason, drug speech. Teachers are neither lawyers nor police officers, and law should not demand that they fully understand the intricacies of our First Amendment jurisprudence. As the majority rightly points out, the circumstances here called for a quick decision, but this consideration is better understood in terms of qualified immunity than of the First Amendment. All of this to say that, regardless of the outcome of the constitutional determination, a decision on the underlying First Amendment issue is both difficult and unusually portentous. And that is a reason for us not to decide the issue unless we must. In some instances, it is appropriate to decide a constitutional issue in order to provide guidance for the future, but I cannot find much guidance in today's decision. The court makes clear that school officials may restrict student speech that promotes illegal drug use and that they may take steps to safeguard students from speech that encourages illegal drug use. Beyond steps that prohibit the unfurling of banners at school outings, the court does not explain what those restrictions or those steps might be. Nor, if we are to avoid the risk of interpretations that are too broad or too narrow, is it easy to offer practically valuable guidance. Students will test the limits of acceptable behavior in myriad ways better known to school teachers than to judges. School officials need a degree of flexible authority to respond to disciplinary challenges, and the law has always considered the relationship between teachers and students special. Under these circumstances, the more detailed the court's supervision becomes, the more likely its law will engender further disputes among teachers and students. Consequently, large numbers of those disputes will likely make their way from the schoolhouse to the courthouse. Yet no one wishes to substitute courts for school boards or to turn the judges' chambers into the principal's office. In order to avoid resolving the fractious underlying constitutional question, we need only decide a different question that this case presents, the question of qualified immunity. The principle of qualified immunity fits this case perfectly, and by saying so, we would diminish the risk of bringing about the adverse consequences I have identified. More importantly, we should also adhere to basic constitutional obligation by avoiding unnecessary decision of constitutional questions. The defense of qualified immunity requires courts to enter judgment in favor of a government employee unless the employee's conduct violates clearly established statutory or constitutional rights of which a reasonable person would have known. The defense is designed to protect all but the plainly incompetent or those who knowingly violated the law. Qualified immunity applies here and entitles Principal Morse to judgment on Frederick's monetary damages claim because she did not clearly violate the law during her confrontation with the student. At the time of that confrontation, Tinker v. Des Moines indicated that the school officials could not prohibit students from wearing an armband in protest of the Vietnam War, where the conduct at issue did not materially and substantially disrupt the work and discipline of the school. Bethel v. Fraser indicated that school officials could restrict a student's freedom to give a school assembly speech containing an elaborate sexual metaphor, and Hazelwood v. Kohlmeyer indicated that school officials could restrict student contributions to a school-sponsored newspaper, even without threat of imminent disruption. None of these cases clearly governs the case at hand. The Ninth Circuit thought it clear that these cases did not permit Morse's actions. That is because, in the Ninth Circuit's view, this case involved neither lewd speech nor school-sponsored speech, and hence Tinker's substantial disruption test must guide the inquiry. But unlike the Ninth Circuit, other courts have described the tests these cases suggest as complex and often difficult to apply. Indeed, the fact that this court divides on a constitutional question and that the majority reverses the Ninth Circuit's constitutional determination strongly suggests that the answer as to how to apply prior law to these facts was unclear. The relative ease with which we could decide this case on the qualified immunity ground and thereby avoid deciding a far more difficult constitutional question underscores the need to lift the rigid order of battle decision-making requirement that this court imposed upon lower courts. In Saussure, the court wrote that lower courts' first inquiry must be whether a constitutional right would have been violated on the facts alleged. Only if there is a constitutional violation can lower courts proceed to consider whether the official is entitled to qualified immunity. I have previously explained why I believe we should abandon Saussure's order of battle rule. Sometimes the rule will require lower courts unnecessarily to answer difficult constitutional questions, thereby wasting judicial resources. Sometimes it will require them to resolve constitutional issues that are poorly presented. Sometimes the rule will immunize an incorrect constitutional holding from further review, and often the rule violates the long-standing principle that courts should not pass on questions of constitutionality unless such adjudication is unavoidable. The last point warrants amplification. In resolving the underlying constitutional question, we produce several differing opinions. It is utterly unnecessary to do so. Were we to decide this case on the ground of qualified immunity, our decision would be unanimous, for the dissent concedes that Morse should not be held liable in damages for confiscating Frederick's banner, and the cardinal principle of judicial restraint is that if it is not necessary to decide more, it is necessary not to decide more. If it is Saussure that tempts this court to adhere to the rigid order of battle that binds lower court, it should resist that temptation. Saussure does not bind this court. Regardless, the rule of Saussure has generated considerable criticism from both commentators and judges. While Saussure justified its rule by contending that it was necessary to permit constitutional law to develop, this concern is overstated because overruling Saussure would not mean that the law prohibited judges from passing on constitutional questions, only that it did not require them to do so. Given that Saussure is a judge-made procedural rule, stare decisis concerns supporting preservation of the rule are weak. Finally, several members of this court have previously suggested that always requiring lower courts first to answer constitutional questions is misguided. I would end the failed Saussure experiment now. I seriously doubt, however, that it does remain. At the plaintiff's request, the school superintendent reviewed Frederick's 10-day suspension. The superintendent in turn reduced the suspension to the 8 days that Frederick had served before the appeal. But in doing so, the superintendent noted that several actions independent of Frederick's speech supported the suspension, including the plaintiff's disregard of a school official's instruction, his failure to report to the principal's office on time, his defiant and disruptive behavior, and the belligerent attitude he displayed when he finally reported. The superintendent wrote that were he to concede that Frederick's speech is protected, the remainder of his behavior was not excused. The upshot is that the school board's refusal to erase the suspension from the record may well be justified on non-speech-related grounds. In addition, plaintiff's counsel appeared to agree with the court's suggestion at oral argument that Frederick would not pursue injunctive relief if he prevailed on the damages question, and finding that Morse was entitled to qualified immunity would leave only the question of injunctive relief. Given the high probability that Frederick's request for an injunction will not require a court to resolve the constitutional issue, I would decide only the qualified immunity question and remand the rest of the case for an initial consideration. So, a very interesting take from Justice Breyer there. He hardly even touches the question of whether or not Frederick's message is protected under the First Amendment. Instead, he really wants to focus in on the qualified immunity question, and in his view, Deborah Morse is entitled to qualified immunity because, like he said, teachers are not expected to know the intricacies of the law like a lawyer or a police officer should, so expecting her to quickly recall student speech protections and precedent in the heat of the moment would be inappropriate and unreasonable. As for me, this is what I will say from the perspective of an average person and not a lawyer or judge or anything. Frederick was a teenager, and teenagers do stupid shit. They like to test boundaries and see how much they can get away with. Frederick did that, and in this case he bit off more than he could chew. I think any person with a sense of humor could look at the sign and determine that it was an attempt at a joke, albeit not very funny one. When I see that sign, I don't see it as a promotion of drug use. I don't see it as reading "we take bong hits" or "bong hits are good" as the majority saw it. I think that because the operative part of the message is "for Jesus," that clues me in that it's a joke because it's such a ridiculous and meaningless expression. Now, earlier I said I was going to comment on Thomas's opinion, and now is that time. I think Thomas's opinion is a threat to the First Amendment freedoms enjoyed by students right now. I understand the idea that school is for teachers to teach and for students to learn, so teachers need to be able to exercise control in the classroom, but the extent of control that Thomas envisions is frightening. In elementary school and middle school, kids are still learning social cues and acceptable behavior, so I give more leeway to teachers in those environments, but in high schools and colleges, that is the time period when lasting aspects of identity and personality form. Those are time periods when our opinions are molded and shaped by our peers around us, so I think stifling that opportunity and overturning Tinker would be catastrophic for students. Thomas also seems to have a misguided perception that the only thing that happens in schools is learning and teaching, which is just plainly false. Some students arrive at school before classes begin and hang out with their friends. Why can't they express themselves then? Or what about at lunch? No learning or teaching is occurring in the lunchroom. Some students might stay after school. No teaching or learning is happening there either, so I find it inappropriate to assume that teachers are teaching for every single second of the school day. Before I get to the outro, I just want to bring up one last question that I would pose onto you guys that wasn't asked during oral arguments. The issue at hand was Frederick's message being in contravention to his school policy, which said students may not make an expression that promotes substances that are illegal to minors. So in your opinion, do you think this case would be different if Frederick's message advocated for abusing drugs that are illegal to minors? For example, what if he said Adderall for Jesus or codeine for Jesus? Both of those drugs are legal, but at least for medicinal use in the United States. Do you think that the expression would be protected though? I'd like to hear your thoughts on that hypothetical as well as your opinions on the case as a whole in the comment section. I've included the links to all of my sources in the description below if you're interested. I recently took the podcast off of SoundCloud because I didn't want to pay a monthly fee to upload infinite hours of content, so you're probably listening to this on YouTube. Sharing this podcast, liking it, subscribing, all that good stuff would be greatly appreciated. As always, if you have any suggestions for cases you want me to cover, suggest them in the comments below, and I thank you for watching. Goodbye.